Good afternoon, everyone. Thank you for joining us today on Facebook Live. We are here at Chisholm, and Kilpatrick. My name is Maura Clancy. I'm joined by Lindy Nash and Emma Peterson, and today we're going to be talking about Agent Orange presumptions. So while we have our discussion today, we're also going to be posting materials on the comments feed next to this video. So as you follow along with us, please feel free to utilize any of the resources that we post in the comments. We also might have time to take a couple of questions through the comment section, so please feel free to leave any questions that you have there. We'll either respond to them in writing, or we might be able to take a couple today while we discuss Agent Orange presumptions. So without further ado, Lindy, why don't you start us off by telling us generally what is a presumption of exposure? So when we talk about Agent Orange and herbicides, things that are going to be brought up today, we talk about the exposure element of an in-service problem or event. Can you tell us about what it means to be presumed exposed?
Sure. So VA actually created these presumptions to assist veterans in getting service connection, so to help make it a little bit easier. So the presumption of exposure basically means that if you served at a certain place during a certain period of time, you're presumed exposed to certain harmful chemicals or environmental hazards, and it kind of takes the place of element number 2 in service connection. So as most of you know, with service connection, you need 3 elements. The first is a diagnosis. The second one would be that in-service event or injury. And the third is the nexus. So if you're presumed exposed to a something like Agent Orange, that kind of takes the place of element number 2, which would be that in-service event or injury.
So the presumptions, it sounds like, are important because they alleviate the burden that the veteran has to prove certain things in order to gain benefits. So if you're seeking service connection, as Lindy said, you need to be able to show that you have a current disability, that there was an in-service event, and that there was a link between the in-service event and the current disability. But the presumption of exposure takes the place of the in-service event or injury prong of the test. So it can be very helpful if VA can recognize or presume that you were exposed to herbicides.
Yep, definitely. And I think we're going to get into more detail a little bit later on in this presentation, but we will be more specific about places you have served, certain periods of time, and so on. But just generally speaking right now, if you've served at a certain place during a certain period of time, you can be presumed exposed to certain herbicides.
And that was a really good overview, I think, of the service connection elements, but just in case anyone has any additional questions about the fundamentals, and in case we don't get to cover them in too much depth today, definitely feel free to access any resources that we have on our website at cck-law.com, as well as in the comments feed here. We've done service connection topics before, we've done other exposure topics before, so feel free to check those out if, for whatever reason, what you were looking for is not covered today. But back to the presumption language and laying the foundation for what we're discussing today. Lindy, the presumption of exposure is different from a presumption that someone is entitled to service connection. So it's different than the ultimate question in the case. Can you, sometimes VA will reference a presumption of service connection. Can you tell us what that means?
Yes, so there's a slight difference here, and it basically just means that VA is presuming that your disability is caused from service, typically due to one of these exposure issues that we're going to get more into in a minute. So this actually takes the place of element number 3, so that nexus opinion that you usually need in service connection claims. If VA presumes that your disability was caused by service, then you actually don't need that nexus element, which can be really huge for your claim.
Great. And Emma, can you tell us what are the conditions or some of the conditions that VA recognizes as being due to herbicide exposure and how they come to those conclusions?
Sure. So some of the common ones that I'm sure many know about that people can get presumed service connection for if they had, boots on the ground in the right place at the right time for herbicide exposure, Agent Orange exposure are diabetes, coronary artery disease, ischemic heart disease, Parkinson's disease, prostate cancer, respiratory cancers, and the list of the different conditions can be found in Federal Regulations 38 CFR 3.309. We'll give you the list of conditions for herbicide exposure. That list comes from, Congress mandated that VA look into this and research it. And so research is conducted by the National Academy of Sciences. The Institute of Medicine branch looks at this and determines whether there is a relationship between the toxins in Agent Orange that are actually, again, listed in the regulation, and these various development of these various conditions. So as Lindy mentioned, if you're in the right place at the right time, so you're presumed exposed, and you have one of these conditions, you're going to get the presumption of service connection. Right. But they each operate independently. So you could be in the wrong place at the wrong time, but if you can show exposure and you have one of these conditions, you'll get service connection. Vice versa, you could be in the right place at the right time, but have some other condition that's not listed as one of the presumptive conditions. If you can get medical nexus information, you can get service connected. So if you've got both, you're golden, you're in the clear. You really don't have to do much other than file your claim, but there still might be some legwork that you have to do if you're missing either the presumption of exposure or a presumed condition.
Okay, great. And the list is contains the conditions that VA will presume due to herbicide exposure, but that doesn't mean that if you have a condition that is not on the list that you believe is otherwise due to herbicide exposure, as you mentioned before, you can't file a claim. It's just that, as Emma said, you will still need to produce the nexus evidence. In other words, you'll still need to show the relationship between what you currently have, if it's a condition not on the presumptive list, and why you believe that was related to herbicide exposure. Usually that needs to come in the form of a medical opinion.
Right. And VA is constantly looking at this as science gets updated, as more research is done, as more people are studied. That list can change. It's changed dramatically in the past. Diabetes, I think, was added in 2002 or 2003. Ischemic heart disease was added in 2010. And I think currently VA is looking at adding, they haven't yet, so don't go, running out there and saying, CCK told me I can get service connected for this, but they're looking at adding bladder cancer, hypothyroidism, and Parkinson's-like symptoms. So you don't have an actual diagnosis of Parkinson's disease, but you have something in that family.
Great. And that last note is important because we do get questions about that a lot. So VA did go on the record and say that they were going to consider or going to look at adding conditions to the list, which I think that they do periodically because the National Academy of Sciences will produce medical information. I think about every 2 years they're commissioned to do a report, and sometimes their report will reveal that there is more evidence suggesting a link between a certain condition that they're studying and herbicide exposure. However, the VA needs to act on that, add things to the list themselves, so that the list is updated and expanded in the regulation 3.309 that Emma referenced earlier. So they have mentioned adding those conditions that you were talking about. They have not done so yet. I think in maybe March of this year, they said it would be within 90 days, and we haven't seen anything yet. So we will definitely be watching that.
Yes.
Yep. Fingers crossed.
Yeah, we continue to watch it, and we would provide an update if we had one, but we are not hearing a whole lot right now.
No. Right.
So that covers the conditions that VA will recognize as due to herbicide exposure. So now we want to talk about where you need to have been to establish that it should be presumed that you were exposed to herbicide. So, Lindy, the big one is Vietnam.
Yes.
Can you tell us about what a person needs to show if they served in Vietnam or near Vietnam to be able to get that presumption?
Sure. So you may have heard the term boots on the ground. That's what we say all the time. So if you are a veteran who served boots on the ground in Vietnam, I'm going to read the dates so I don't mess them up. January 9th, 1962 through May 7th, 1975, then you will be presumed exposed to herbicide agents. So that is great for your claim, especially if you have one of those disabilities that Emma just listed. If you have one of those disabilities, you have a diagnosed condition on that list, and you were in Vietnam, boots on the ground during that period of time, then in theory, you should be all set and service connection should be granted. VA does sometimes make mistakes and may deny it incorrectly, but typically you should be granted service connection if you were boots on the ground in Vietnam during that period of time and you have one of those conditions listed in 3.307E. Right.
I think, yes, 3.30, look at both 3.307 and 3.309.
Right.
For the full picture of what you can get done.
Right. Yep. So typically that is kind of the biggest thing people think of for presumed exposure cases, boots on the ground in Vietnam.
Okay. Yep. And then recently there have been developments to VA's policies and the law about veterans who served in the waters surrounding or in Vietnam. Emma, can you tell us about that?
Sure. So before a major federal circuit case came out and then Congress acted on it, there was a distinction between brown water veterans and blue water veterans. So brown water veterans were those that were on vessels that traveled the inland waterways of Vietnam. It sort of varied depending on what period of time you're looking at. VA's definition evolved over time. So for a time, people who did dock into Da Nang Harbor, that was brown water, and then they changed their mind and decided, no, that's blue water, and prompted a whole host of litigation. So fast forward to this year, a major decision comes out from the Federal Circuit, Procopio, that talked about how, since Congress decided to call Vietnam the Republic of Vietnam, that really meant the true international law definition of a country, which includes up to 12 nautical miles off the coastline. After that decision came out, Congress acted and enacted some blue water legislation. So now we have this legislation that gives us precise coordinates generally fitting within that 12 nautical miles offshore. So any veteran who served within 12 nautical miles of Vietnam or within those coordinates in the legislation can now be presumed exposed to herbicides, which really opens it up to all these Navy veterans that have been talking for years about how, listen, Agent Orange and herbicides were sprayed on land mass, but it leached into the water.
Right.
The water is being circulated through our ship. We're bathing in it. We're drinking it. We were exposed to. So this extends the presumption to all those folks now, which is great and really opens it up. One thing to note is that the Secretary has issued a stay. Secretary of VA has issued a stay on all these claims, meaning he put the pause button on them. So you can still file for service connection. If you have filed for service connection, you're a blue water veteran, your claim is in a queue, it's in line. They're just not making any decisions on them yet until they figure out how they're going to decide what boats were where at what time. So that stay is in place until January 2020. I think still important to get your claim in as soon as possible. Because your effective date will be governed by that, but just note that there probably will be a little bit of a wait before you hear something back.
Sounds good. Yeah, this is very important stuff because it's very new, and as Emma said, they have stayed these cases, so sometimes that might make someone think that they should be deterred from filing a claim, but that's not really the case. Once they lift the stay and start working on these cases, it will be important to have your claims in. So definitely take a look, see if you fall within the 12 nautical miles. Hopefully VA will come up with some information that might be helpful for people to figure out if they were. And we have some resources on this, I believe, on the website as well, which is, again, at cck-law.com.
Right. Yeah, there was another Facebook Live on Procopio specifically that was really helpful. I think Zach and Brad talked about how about 80,000 veterans are going to be affected by this Procopio decision. So when we say it's huge, it really is going to be a big deal in VA law. So definitely get your claim in. And if you already have one in, like Emma said, just be patient a little bit longer.
And outside of Vietnam, there are also presumptions in place for veterans who served on or near the Korean DMZ, which is the demilitarized zone. Lindy, can you tell us about how that presumption works if the veteran served there?
Yep. So just like Maura said, if you served on or near the Korean DMZ, then you will, or you can be presumed exposed to Agent Orange. Again, I'll read the date so I don't get it wrong. April 1st, 1968 through August 31st, 1971. The only trick here is that VA has recognized, and the Department of Defense has recognized certain units that they will presume exposed. This is a relatively long list, and we have it on our website, and it's also on VA's website, so I suggest you go check it out. If you served during that period of time in Korea on or near the DMZ, then you should definitely go look to see if your unit is one of the recognized units. VA will often give you pushback if you were not in one of those units, so it might take a little bit of legwork, as we talked about previously, but definitely still possible to get service connected via Agent Orange exposure.
Great. And DMZ cases can be tricky because instead of the standard, if you were in Vietnam, you're presumed exposed standard, really, that they use for Vietnam veterans, at the DMZ, they say if you served on or near the DMZ. Right. And so the question becomes, and a question that VA hasn't really answered, is what is near the DMZ?
Right.
Is it within 500 feet? Is it within 5 miles? We don't know.
Is it south of the civilian control line? It gets really interesting and tricky. So certainly talk with your representative, VSO, colleagues at DAV, an attorney, your friends from service about what they're hearing and what they're seeing, because it can get tricky and confusing, but certainly winnable.
And another thing that can be helpful if you are a veteran that served at the DMZ is talking about proximity to the DMZ in lay statements. So it won't just be enough to say that you served in Korea in the time frame, or even sometimes showing that you were in a particular unit. Obviously, there's the list of recognized units, but records aren't foolproof, and we know that records can get lost over the years. We're talking about dates of service from decades ago, so the records might not be totally complete. And so if you can provide VA with more information about where you were, if you remember, that might help them figure out whether your proximity was near enough to the DMZ. So things like that can be helpful to try to piece together what you need. And along similar lines, there's also the issue that comes up with people that served in Thailand.
Right.
So herbicides were used in Thailand, and VA recognizes this, but there's currently no presumption the way that there is for Vietnam veterans, for Thailand veterans. So does someone want to talk about what VA is doing with these cases? How they assess the facts here?
Sure. I'll start, Lindy, and then you back
I'll
me
jump
up. So like Maura mentioned, there's no presumption, but there is a policy, and it's a pretty good policy to start. So for veterans that were stationed on certain Royal Thai Air Force bases, any time between the same period of time for Vietnam veterans, January 1962 to May 1975, if your military occupational specialty or your job duties or what have you put you on the perimeter of that base, or brought you in contact with the perimeter, VA should concede exposure to herbicides. So what does that mean, the perimeter? So they were spraying these bases operationally with herbicides. VA has conceded this, same herbicides that were used in Vietnam, for tactical reasons, to prevent, ambushes, attacks, things like that. You got to be able to see what's going on to guard the base. So there are certain MOSs that VA will basically, as a policy matter, agree you were on the perimeter. So veterans, in the Air Force that had military police, dog handler duties, perimeter security, or other credible evidence that you were on or near the perimeter will get that exposure conceded. The bases that VA is looking at right now are Utapao, Ubon, Nakhon Phanom, Udorn, Takli, Karat, and Dong Muang.
Very good, Emma.
Thanks. Yeah. I tried.
Always good to try.
Just got to give it a try. Yep. But generally, those are the major Air Force bases. Army veterans, so not just Air Force folks, but Army veterans who are over there who provided perimeter security also get this presumption. So again, it's a matter of putting yourself in the right place at the right time. Were you at one of these bases? And did you go across the perimeter? Did you serve along the perimeter? Were you on the flight line? Was the machinist shop next to the flight line, which was next to the perimeter? Were your barracks next to the perimeter? Were you in supply? Did you have to drive across the perimeter each day into town to get supplies and drop them off other bases and come back? So it's a little bit broader than maybe VA wants to concede first go around. But again, similar to the Korean DMZ stuff, you need to provide maybe some extra evidence beyond just your service records to get this policy presumption.
Definitely. We do statements all the time with our clients who served at these Thailand Air Force bases. Like Emma said, just proving that they were, maybe they crossed the perimeter every day or once a week or whatever their job was. Usually they have good evidence as to being near the perimeter. So we do statements all the time to substantiate that.
And we try to make sure that we keep it as broad as possible. And I think that that's probably the best approach, because even though the policy talks about your occupational duties in service, the policy is still other credible evidence that you served on or near the perimeter. I think something along those lines. And so anything that is relevant to exposure to the perimeter, even extracurricular activities.
Right.
Some places, some people smoke cigarettes along the perimeter, or played cards with their friends along the perimeter, or went in and out of the base several times, like Lindy said, regularly, multiple times a week, a month. So anything like that we try to bring in. Sometimes the barracks were even placed along the perimeter.
Right.
So that's not going to be something that VA can tell based on your occupational specialty, whether you were there, but information that you can provide, that you can remember, is very, very important in those cases, because again, just like with the DMZ rule, it's sort of this vague near the perimeter, near the DMZ, and that's undefined, and that can be difficult for VA to get right, frankly.
Yeah.
Or consistent.
Yeah, and I was just going to say, with if you have any buddy statements as well, maybe there's a friend that you served with who can attest to you being on or near the perimeter. Those are helpful. Also, pictures. We submit pictures all the time. If you have anything to show where you were, that's helpful. Maps even of the Air Force bases, we submit those sometimes. So any type of evidence like that to prove where you were is great.
Great. And there's also, I believe, a presumption, and Emma, you can tell me if I'm wrong about this, for veterans who worked with C-123 aircraft.
Right.
Can you tell us about that?
Sure. So the C-123 aircraft actually sprayed Agent Orange in Vietnam. They were sent back to the U.S., used by the Air Force and Air Force Reserves. So veterans might be exposed to herbicides who never even set foot in Vietnam, Thailand, DMZ, were stateside the whole time during the conflict. So if you were a member of a certain Air Force unit, where contaminated C-123s were assigned to, and you had regular contact with the aircraft between 1969 and 1986. So these years are different than the Vietnam boots on the ground presumption exposure, and you developed Agent Orange disabilities, you can get presumption of exposure and service connection. Reservists at certain bases also between the same years can get the presumption, but again, you're going to look at the regulation 3.307E, right? One?
The disabilities are in E.
Yes.
And I think
the C-123 regulation is 3.307A.
Thank you.
Yes.
To get the exact precise units and information about who gets the presumption, because it's a little bit more nuanced. Right. I will say that, at least from what we've seen, these generally get granted. If you have the right unit and you have the right disabilities, we don't see a lot of pushback from VA on granting this condition.
But still good to know, because this is a lesser known presumption, I think, when we talk about herbicide exposure.
Absolutely.
And finally, there is a list of other locations that we haven't talked about today where herbicides were used, tested, stored, etc. The locations are very variable, and so are the dates of the storage and use. Yep. I think a lot of them do line up with the Vietnam era, but not exactly at all, based on the years that we've talked about today. We will make sure to make that list available through our website, either through the comments or through the website, as we said before, at cck-law.com. It's also available on VA's website.
Right.
Did anyone want to add anything? Because I don't think we see a ton of those cases, but it is important to know that there are some bases, some locations where herbicide arguments would be important.
Right. Yeah. VA maintains a list of locations both within the states, in the United States, and outside the United States, where herbicides were either tested or stored. So there were folks that were involved in the testing of Agent Orange and herbicides before they actually kind of went into use full scale, and then also the disposal of any leftover product after the conflict was over. So certainly take a look at that list. You might have a very clear memory of working with it, and you may in fact be entitled to a presumption.
Great. Did you see Rhode Island was on the list?
I did see. There is a location in Rhode Island.
I didn't know that.
I did not know that either.
Yeah. Yes,
I'm going to have to look at it again. Once again, everyone, we're here today talking about Agent Orange presumptions at Chisholm, and Kilpatrick. We're going to wrap up with some final questions, but as we have said before, please feel free to utilize the resources that we've been posting throughout this discussion through the comments feed. So we talked about the presumption of exposure, which replaces the in-service event element for service connection. So it's an important presumption if you're trying to establish that you have a condition that's due to herbicide exposure. We also talked about the presumption of service connection and VA's list of conditions that they will presume as being due to herbicide exposure. And we talked about the locations and dates where herbicides were used, in what time frame, and we got into a little bit what kind of evidence you might need to substantiate your claim that you were exposed to herbicides if it's necessary. So do you both want to offer some, in your experience, some common mistakes that you've seen the VA make with respect to herbicide exposure and specifically the presumptions?
Sure. I think one of the big ones that you see is VA especially for Thailand veterans, talking about how, based on old information, that the herbicides used were just commercial and not tactical. And for all intents and purposes, there really is no distinction between the herbicides that were sprayed in Vietnam and the herbicides that were sprayed around perimeters in Thailand. And again, that's old information, and VA is a big institution and can be slow moving. So it is important to push back on that and appeal that, because the most current information, and even General Counsel for VA themselves has conceded that the same type of herbicide was used in Thailand. So that's old information, and that's a common mistake I think we see the VA, either the regional office or the board, unfortunately making. But there are avenues to appeal that and correct that mistake. So that's one thing I would certainly be on the lookout for.
Definitely. Because the way in which you use the substance doesn't change the substance itself. That's always kind of my favorite thing that they say. It's like, well, it was used for this purpose. It wasn't used for this other purpose, but we're still talking about the same.
It's the same chemical. So it, tactically or otherwise, I don't care if it was used for garden maintenance, it's still the same dioxin.
It's still harmful.
So same thing with your MOS. You're on guard duty or you're playing guards. The toxicity doesn't change because of your occupational or recreational activities. So all things to keep in mind.
Those are good points.
I was going to say actually the same thing about Thailand cases. I think I probably see the most pushback with those, especially with what Emma said, and also, again, with the military occupation. We have clients who were in accounting or maybe worked in reception or did something that isn't typically thought of as being on or near the perimeter, and VA does not like that. So again, lay statements are really important. Buddy statements are important. Anything, maybe you went to town daily or weekly to have dinner and you crossed the perimeter. Whatever it is, showing that you were on or near the perimeter is important. So definitely push back on that too.
Great. And along those same lines, your lay statements are important, and sometimes VA doesn't always appreciate that. And so we have had, plenty of instances and cases where the records, like the unit records or the personnel assignments from the military, don't specifically provide enough documentation or enough evidence of herbicide exposure, and VA will kind of hang their hat on that and say, well, there's nothing in here about herbicide exposure. There's nothing in here about your exposure to herbicides or use of herbicides or being near them, and so we can't concede exposure. But plenty of people have described instances credibly in which they were near locations that VA knows to have been sprayed. Some people don't have records that they were in Vietnam. This is a more rare case, but we have seen a few instances where the VA refuses to accept a statement that a veteran was even in a particular location. So as Lindy and Em, I think, have both covered really well, get your evidence in. If VA is relying on the absence of evidence or the lack of enough records, try to supply a record for them because they're supposed to be considering the evidence that you submit.
Absolutely.
Any final thoughts for people to keep in mind? Or
Nope, just keep an eye out for any changes in the presumptions, and if they do change, be sure to get your claim in as soon as possible after that change.
Great.
Yeah, and I would just say, because Procopio came out, it's okay that it stayed. That doesn't mean anything bad for your claim. It just means get it in there. If you are one of those veterans with one of these conditions and you served within 12 nautical miles of Vietnam, definitely file your claim. Do not hesitate to do so.
Excellent. Any questions? Perfect. Thank you all for joining us today. We will see you next time.